Good afternoon, everyone. Welcome to this week's discussion and update on COVID-19 webinar. My name is Kathy Purdy. I'm the marketing manager here at Schoeneck King. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Also, if you would take a moment to complete the brief survey once today's webinar has finished, we would appreciate that, as our attorneys do review the survey results and appreciate your comments for future subjects and topics. So to get things off, I'm going to hand it over to Adam Masterleo in our Syracuse office.
Kathy, thanks so much. And thank you to everyone who is joining us this afternoon. Welcome, as Kathy said, to our weekly installment of the coronavirus update. So this week we have a nice program for you. We're going to start off with an update from Jeff Shear on PPP loan developments. After that, I'm going to give you a little preview of what the Biden administration has said about its plans for COVID-19 related leave. Katie Anderson is then going to give her weekly update on what's going on in Albany, and I know everybody looks forward to that. We have a little bit of special presentations, the final two, a little more specialized. Mallory Campbell from our New York City office is going to talk about higher education relief package provisions, which were included in the most recent legislation. And then Colin Leonard is going to give us an update on WARN requirements and how courts have been viewing those in light of the pandemic. So with all that, let's get started. I'll turn it over to Jeff Shear on the PPP.
Great, thanks, Adam. It's good to be back with everybody. So there's been some developments on the PPP program over the past couple of weeks. Nothing terribly earth-shattering, but I do want to focus on a couple of items that seem to be coming up with my clients over the past couple of weeks. So if you remember, there's a couple prongs that have to be satisfied to qualify for this second round of funding. And one of those prongs is a reduction in gross receipts. And that question has come up repeatedly. And in fact, this morning, maybe it was late last night, the SBA was kind enough to issue some guidance on how we measure gross receipts. It's somewhat helpful, not completely, but somewhat helpful. So I'm going to go into a little bit of detail here. The first piece is, and as we've said before, we're measuring gross receipts from 2020 versus 2019. And there's two time periods you can actually use to measure. One is looking annually at gross receipts in 2020 versus 2019 on an annual basis, and ensuring that you have a 25% reduction over that annual time period. And the second is looking at one particular quarter in 2020 versus the same quarter in 2019 and seeing if you have a reduction of 25%. And I think in that case, the SBA is saying, listen, you can look at it over a whole year, but we acknowledge the fact that things may have gone up and down over the course of 2020. That's why we're allowing you to compare quarter versus quarter. The next question that has come up is what is included in gross receipts? And that question was, for the most part, answered this morning in the guidance that was handed down, and I'll put a link to that later in the materials here. Generally, we're looking at income minus expenses, very basic. First round PPP funds and EIDL funds are not included in that calculation. I have received the question on a few times whether other funds received under the CARES Act are also excluded from that calculation. And my interpretation of the definition of this calculation is that it's just not clear. I could make an argument either way. I think the best bet is to talk to your banker and see if they want you to exclude other funds that you may have received under the CARES Act. That's the best advice I can give you there because it's just not clear. The other question that I've gotten on a number of occasions is whether we include unrealized revenue in our calculation of gross receipts. This is, let's say, investment income that's just not realized by, let's say, a not-for-profit or a tax-exempt entity on investments that you currently hold? My answer there is I believe unrealized revenue is not included because we are only directed to include amounts that are actually received, which I think is very helpful. The other thing that happened today is in this guidance that was handed down for exempt entities, it actually gave us a very helpful way to calculate gross revenue, referring to specific line items on the 990. So, for example, if you're looking to calculate gross revenue, they tell you to look at Part 8 of your 990 and take line 12 and reduce that by line 6B, 7B, 8B, 9B, and 10B, which are basically all of your expenses, to arrive at the correct number. So it was actually very helpful today. But I think that that question of unrealized revenue has come up a couple times, so I wanted to mention it. The next piece I wanted to mention, we got some guidance this morning, is what documentation is required. So here, what the SBA has done is they've created two buckets. One is the under $150,000 loans. The other is the over $150,000 loans. The documentation is the same for both, but for loans that are under $150,000, the documentation is actually provided at the time of forgiveness. For loans over $150,000, the documentation is provided with the application. Now, what can be provided or what has to be provided? You have an option of one of three packages. One are quarterly financial statements. If those financial statements are not audited, they have to be kind of signed and certified by the organization. Now, I guess who has audited quarterly financial statements? Not sure who does, but if you do provide those. If not, you have to sign and certify them. Second option is providing quarterly or monthly bank statements that show your receipts. And third set of information that can be provided are annual IRS income tax filings. If your, for example, 2020 is not yet completed and filed, it has to be completed and certified by the organization, just not filed. Because, at this point in time, we're 19 days into the year. I don't know anyone that has really completed their 2020 income tax filings. And if you have, you are, way ahead of everybody else that I know. So the other piece I wanted to mention is, and I do have people asking me this question is, if my company wasn't necessarily in business prior to February 20th, 2020, do I qualify? And the answer is probably not, because under the guidelines, you have to have been in business on February 20th, 2020 to qualify for both first draw and second draw loans. You can't form a new entity for purposes of qualifying. You can't spin off an existing division. In an attempt to isolate revenue, you can't spin off a division into a new company for purposes of qualifying. Even in that regard, the ownership affiliation rules would probably make you ineligible. So it's very key that the business that is making application has been in existence for about a year now, 11 months or a year now. There was some other guidance that came down on additional amounts that you can get under your first draw. So if you had qualified for a first draw loan amount, but for some reason you didn't take the entire amount that you qualified for, or you returned some of the funds before using them, before even putting your forgiveness application in, there is some limited opportunities to get those monies as part of a first draw amount rather than going to a second draw. So if you're in that small bucket of people that may be qualified for, I don't know, $700,000 loan, but you took $700,000, but you gave back $100,000 immediately for some reason, you could go back and claw back that $100,000. So that's something to consider. When calculating the loan amount, this is something that I think can also be helpful. I wanted to mention. When calculating your loan amount, we've talked about this numerous times, 2.5 times your average monthly payroll. For purposes of considering calculating your average monthly payroll, you can use either 2019, 2020, those calendar years, or the trailing 12 months. So I think when calculating, you're going to look at those 3 time periods and probably figure out which one gives you your highest average monthly payroll. And the last thing I wanted to mention, I think I don't want to lose sight of any of this, is that even on these second draw loans, the original rules that we talked about on many, many occasions concerning FTE requirements at the beginning of your covered period versus the end of your covered period, wage reductions during that period, all those rules still apply. So this second draw is great and wonderful. And I think if you qualify, you should be seeking these dollars, but also keeping in mind that you still have these FTE requirements and wage requirements to keep in place, because the whole purpose of this program is to protect the paychecks of our employees. So with that, I'll turn it back over to Adam, and thank you very much, and I'm sure I'll see you all again.
Jeff, thank you so much. That is a lot of very helpful information, a lot of detail in that guidance. So if you have any questions, feel free to reach out to Jeff. He is certainly an expert on the issue. So I am going to take a couple of minutes and talk about the COVID plans from the Biden transition team. You know, we try to stay ahead of things for you to anticipate issues that are coming down the pike. And this is one where I think we received a little bit of a clearer picture over the last week or so when President-elect Biden released his COVID plan. And first, I want to start with where are we now in terms of COVID leave? So New York State emergency paid sick leave when an individual has a quarantine order, that is still in place. That has not changed. The Families First Coronavirus Response Act leave, both the emergency paid sick leave and the emergency family medical leave, expanded emergency family medical leave, expired on December 31st, as everyone knows. Employers can continue to offer the FFCRA leave on a voluntary basis and continue to receive the tax credits through the end of March of this year. What the Biden transition team has done is release this plan they've called the American Rescue Plan. It includes a lot of information, most of which I'm not going to get into, but there are a number of provisions that are very relevant for employers. I should also say at the beginning here that this is not a proposed legislative plan. There isn't textual changes to statutes. These are more themes that the Biden administration has said they are going to be pursuing in the first 100 days of the administration. So with respect to the FFCRA, the Biden administration has said that part of its plan is continuing it or restarting it. It expired, like I said, on December 31st. The Biden administration wants to put it back into place until or through September 30th of this year. Some of the key changes that the Biden plan has proposed for the FFCRA leave are as follows. First of all, if you recall, the FFCRA did not apply to employers who had more than 500 employees. It also had limited exceptions for employers who had fewer than 50 employees. The Biden plan gets rid of those exemptions and proposes that the FFCRA apply to all employers regardless of size. Another important change in the Biden proposal is that the exceptions for healthcare providers and emergency responders would be eliminated. If you recall, in the previous iteration of the FFCRA, healthcare employers could exempt nurses, for example, from the FFCRA as healthcare providers. This was an important thing for healthcare employers because it helped them deal with or reduce staffing issues. So the FFCRA provides much more generous leave than New York State's emergency paid sick leave. And there's a concern that if this legislation gets passed, it may place a burden on healthcare providers. In addition, the emergency, one thing many people didn't realize, the emergency responder exception included public works personnel. So public employers who had DPW employees could say to those employees, you do not qualify for the FFCRA emergency paid sick leave or expanded FMLA because you are technically emergency responders under the definition. The Biden proposal eliminates those two exceptions and would have the FFCRA and its protections apply to all employers regardless of size. A couple of other changes that are in this Biden plan. First of all, they want to expand the Emergency Family Medical Leave Act to 14 weeks of paid benefits. It wasn't entirely clear the amount of emergency paid sick leave that they were going to be offering. If you recall, before it was 80 hours. We don't know whether or not the Biden plan would expand that 80 hours or not, but we know that they do want to expand the EFMLA leave to 14 weeks. The plan also discusses an expansion of categories, and it's not clear whether this expansion of categories will apply to the emergency paid sick leave, the emergency family medical leave, or both. If you recall, under the prior FFCRA, Emergency Family Medical Leave Act was only available if you as an employee had childcare issues. The Biden plan, it's not clear if that's going to expand to the other categories which were available for emergency paid sick leave. One thing we do know is that the plan includes an additional category for emergency paid sick leave for individuals who need to take time to go get the vaccine. So this would be a new category of leave under the Biden plan. Some other miscellaneous changes that the Biden plan included are an expansion of emergency paid sick leave to federal workers. That wasn't in the first FFCRA. It talks about changing the maximum weekly benefit to $1,400, which seems to be less than the $511 a day that the prior FFCRA guaranteed, but it's not clear again from the Biden plan how this would be calculated. It also talked about expanding the tax credit availability for employers with fewer than 500 employees. And this change was particularly interesting because the plan is going to require employers with greater than 500 employees to provide the FFCRA benefits, but it's only going to provide the tax credit for employers with fewer than 500 benefits or 500 employees. So that is something to keep an eye on. The plan also talks about reimbursing state and local governments for their expenses paid for FFCRA leave. Now, this was very important to local governments because with the first iteration of the FFCRA leave, they had to provide the leave, but they didn't get a tax credit. So the Biden administration has talked about reimbursing those local and state governments for expenses related to FFCRA leave. A couple of other interesting provisions in this plan for employers. One is an expansion of unemployment benefits. And the plan was very vague in how or what benefits would be expanded and to whom they would be granted. So that's something that the administration is certainly going to have to flesh out in the coming days as they try to enact their proposals. And one final interesting provision was that it talked about encouraging employers to provide back hazard pay. It talked about large employers to provide back hazard pay to those emergency or essential workers who were on the quote unquote front lines during the first part of the pandemic. And it's an interesting concept. There weren't really many details other than the plan document talks about or references grocery stores as an example, trying to encourage these grocery stores to somehow pay back or give enhanced back hazard pay to those employees who are working in the front line, so to speak. So those are some of the interesting things we are going to keep an eye on. Like I said, the Biden administration hasn't reduced any specific proposed legislation. This is just an outline or a framework for their plan going into the beginning of the term. So we will obviously keep an eye on that. We will keep you updated on any developments, and please feel free to reach out if you have any questions. With that, I am going to turn it over to Katie Anderson, who is going to give her weekly update on Albany. Katie?
All right, here we go. Thanks everybody for being with us again today. First, let's start off by taking a look at where we're at in New York. Last week, I said to you, it looks as though the cases are dropping. I am happy to say that I was correct. not just because I was correct, because it also means that cases are declining in New York. When you're looking at this chart, it does show that there is a drop-off that's happening. One of the biggest concerns, though, is you're still seeing an increase in hospitalizations, and you're going to still see an increase in death rates over the next at least 2 weeks, as a result of the peak that appears to have happened in the middle of January. I would say, I'm looking at a calendar, like January 11th is when the peak was. The biggest threat right now facing New York as a result of COVID-19 are the new variants. There are 3 that have been identified by the CDC and posted on the CDC website. There is a new one that just emerged last night, was the first time it was reported out of California. So these 4 variants, there are a few things that need to be noted. First of all, they have all developed independently of one another. The problem there is, as the virus mutates and new variants and potentially different strains develop, the biggest concern is, will the vaccine still remain effective? So far, these new variants, the vaccine appears to still be effective, and experts have been looking at when one develops that the vaccine will be less effective against. It appears that the vaccine will still be about 50% effective against new variants that may pop up. Again, this is all very theoretical at this point, but it is likely going to be reality within the next 2 months. The CDC is predicting that the UK strain is going to become the dominant variant in the US by March. That is the strain that is extremely contagious. You just have to be really careful about that one. And the side effects of it, everything's still the same, except for the fact that it is more contagious. That makes the challenges of vaccinations all the more key. New York, over the past week, has finally developed a vaccination hub where you can go and check and see, and they update it every day at 11 o'clock a.m., how the state is doing with vaccinations. The state has administered 72% of the vaccines that it's received. Out of those regions, the best performing region is the Southern Tier. The second best will be the North Country, 2 regions that have the lowest population and have received the fewest amount of vaccines. It's obviously going to be an easier thing to vaccinate 24,000 people versus 378 like you see in New York City. The biggest issue with vaccinations at this point comes to what vaccines are being distributed to New York. This is from that vaccination hub that New York has developed. These are the vaccines that the federal government has allocated and delivered to New York State. We are looking at, obviously, that's not enough to vaccinate the state, and the rate it's going is extremely slow. And so looking at what the Biden administration has planned for the upcoming week, even to ramping up vaccines, that will be very important to keep our tabs on. It's going to be a big change. The Biden administration has spoken about putting the full force of the federal government behind vaccine distribution and administration. That will involve invoking the emergency powers of the federal government. That will involve setting up FEMA at places. So I think in the next 2 weeks, we will see a different story in terms of vaccine distribution if we're able to successfully implement those mandates from the president-elect. Looking at the budget, the governor is currently giving the budget update right now. The state budget has been predicted. You've heard me constantly saying the state has a terrible deficit. Turns out the state's deficit is not as bad as they thought it was going to be. The comptroller, Tom DiNapoli, put out a study basically showing that the budget hole is not as bad as anticipated because tax revenue was $4 billion higher than expected. What that means is the state still needs money. The governor's presentation today, he said that the state would need is facing a $39 billion revenue shortfall over the next 4 years. The governor's budget update today was asking the federal government for $15 billion for New York State in order to implement many parts of the state's budget. The governor has even at this point, as of today, threatened to sue the federal government if such funds are not released to New York State. Looking at where we're going with this, it's very unclear. We haven't been able to get our hands on the text of the actual budget, and I just refreshed the page before I started speaking. It just hasn't been published yet. What that means is it's hard for me to talk to you about what's in the budget without knowing what's in the budget. And by next week, we'll have a better picture. But this document will really tell us where New York is going to go in 2021 to both combat this virus, but also just our day-to-day lives, how it's going to impact your businesses and how it's going to impact your bottom lines. That is all from me, and I hope that you all have a wonderful rest of your day.
Katie, thank you so much for that update. There's quite a bit going on. You know, we thought it would stop at some point, but it continues to develop. There are continuing new developments every week. So thank you for bringing those to us. All right, next we're going to turn to Mallory Campbell. Mallory is an attorney in our New York City office. She's going to give us an overview of the higher education relief package provisions, what we know and what we don't know. So Mallory, please take it away.
All right, thanks, Adam. So as many of you may remember, back in March when the CARES Act was passed, it established this Higher Education Emergency Relief Fund, or known as HERF, to provide funds for colleges and universities. The CARES Act set aside about $14 billion towards HERF. Since that time, we haven't seen much help until this new budget bill that was signed into law on December 27, 2020. So this law, it sets out a number of different COVID relief efforts, but I'm going to just focus on the additional HERF funds and the changes that we've seen from the CARES Act HERF funds to the HERF funds under this new act. So this new act provided about $22.7 billion towards HERF. The main changes we've seen from the CARES Act to now is the expanded uses of funds, a modification of the share that has to be used for financial aid grants to students, and the inclusion of exclusively online institutions. So for allowable uses, under the CARES Act, institutions had two buckets of funds. Half of the funds were supposed to be used for student aid grants, and the other half could be used for costs relating to switching to online instruction and for any additional aid grants to students that the institutions wanted to give. This most recent act expanded the allowable uses that institutions can use HERF funds for. So institutions can now use these funds to defray expenses associated with coronavirus, including lost revenue, carry out student support activities, and again, to provide financial aid grants to students. So this new list provides more flexibility to colleges and universities when you compare it to kind of the more restricted uses under the CARES Act. Just a quick note on the expenses associated with the coronavirus for one of the uses. This can only be used for costs incurred on or after the date that was signed into law. So on or after December 27, 2020. Under the CARES Act, the student aid portion was half of what institutions received. Under this new bill, institutions must provide at least the same amount of funding in student aid grants as they were required under the CARES Act. But since, as we've seen, there's more funding under this act than under the CARES Act, most institutions should have a larger share of funds available for their institutional support. So if an institution received $2 million in CARES Act HERF funding, they were required to provide $1 million in that money towards emergency grants for students. If that institution now receives $3 million under this new act towards HERF, the institution must provide $1 million in student financial aid grants, and then they can use that remaining $2 million for other uses. So another change we've seen is that institutions have to prioritize students with exceptional need, such as students who receive Pell Grants. This is not something that we saw under the CARES Act, so institutions should carefully document how they're prioritizing students with exceptional need when they distribute those grants. For institutions that already received HERF funds under the CARES Act, no action is required. They don't have to do a new application. They should just automatically receive the additional funds. For institutions that, for whatever reason, did not receive HERF funds under the CARES Act, they must apply by April 15, 2021. And this would include institutions that provide exclusively online courses prior to COVID, as they were not eligible for HERF funds under the CARES Act, but they're now eligible. So a couple things are unclear at this point. The first has to do with student aid grants for students who are not US citizens. Under the CARES Act, in both guidance and a pending interim final rule, the department prescribed that only students eligible for Title IV federal student aid could receive emergency grants under the CARES Act. This has been challenged in several jurisdictions at this point. For this most recent law, the department explained that this interim final rule does not apply. However, in a recent call with higher education leadership, a department official indicated that it still views students who are not US citizens as being ineligible to receive grants on the theory that only citizens may receive public benefits. So at this point, it's not really clear whether non-US citizens are able to receive these student grants or not, but this is something that we're going to keep our eye on. Another issue that's not entirely clear is student loan relief. So in March 2020, student loan payments were suspended. Former Education Secretary Betsy DeVos had recently extended these actions until the end of January. This budget bill, the 2021 budget bill, did not say anything about this. It did not continue this relief. So as of now, it is set to expire at the end of January. But when President-elect Joe Biden takes office tomorrow, it's likely that he'll continue this pause on student loan payments, but we will be sure to keep an eye out for that and see what happens and keep you updated on anything that occurs. And that's all I have, so I'll hand it back to Adam.
Mallory, thank you so much. Really interesting and important information for our higher education clients. And with that, we'll turn to the last, but certainly not least, presentation of the day. It's Colin Leonard, who is an attorney in our Syracuse office in the Labor and Employment Department, and he's going to give us an update on recent developments relating to the WARN requirements.
All right, thanks, Adam. Hello, everyone. Obviously, we're talking about WARN in this situation of COVID because WARN is probably the statute that's most implicated when we're talking about significant numbers of layoffs, reductions of employees. So we want to try to just give you the brief background on the WARN Act and then discuss a couple of developments that have occurred over the past week or two to give you some sense of what how courts are looking at the WARN Act. So essentially what the WARN Act is, there are two pieces that we're thinking about in New York. One is the federal law that's been in place since 1987. The federal law, the WARN Act, requires 60 days advance notice to employees and others prior to the employer conducting a mass layoff or a plant closing. As indicated on this slide, really the WARN Act, the federal law was really targeted at larger employers. So you had to, for mass layoff, you either had to have employment losses of at least 500 employees, or if it was fewer than 500, whatever that number is, was at least 50 and at least 1/3 of the employees at that site of employment. The other trigger was a plant closing, and that's where an employer terminates or shuts down either temporary or permanent site of employment, and that results in employment loss of at least 50 employees. So there's no percentage requirement when we're thinking about plant closing. Again, we exclude part-time employees when conducting the assessments under both federal and New York WARN law. Under New York, if you can switch to the next slide. Under New York, what New York did in 2008 decided, and New York is one of many states that have what are so-called MiniWARN laws. These are laws that apply in situations where you might not reach a trigger under the federal law. So it's a smaller number of employees to trigger the requirement to provide the notice. So for example, the mass layoff number has been cut in half to 250, or if you're below that number, at least 25 employees with, again, the requisite 33% of the employees at that site. Or, and this is the one that I see most often in New York, is a plant closing, where we're talking about the shutdown of a site within, or a facility or operating unit within that site that implicates an employment loss of 25 or more employees. And most notably, unlike the federal law, New York requires a longer period of advance notice. We have to provide 90 days notice in New York. So once if you've triggered the WARN law, this slide, you've got to provide the notice in advance to these individuals, the affected employees. If you've got a union, the union representative, New York State Department of Labor, who will take the information and post the fact that you have triggered WARN on their website, so it does become public. You also have to notify your local workforce investment board. In 2020, there were 2 new additions to the requisite recipients of the notice. Like the federal law, now the New York law requires that the chief elected local official also receive the notice, as well as, and this is in addition to the federal law, the school district official as well for the district in which the facility is located. And finally, in a pretty complicated provision, employers are also required now to notify each locality that provides various police, firefighting, emergency medical or ambulance services or other emergency services. Very often that's going to overlap with the chief elected local official, but not necessarily given the varying degrees of overlap of law enforcement, firefighting, and emergency services in New York. So why is WARN such a big deal to employers? Because it's a significant liability if you violate the law. On the one hand, you're faced with giving the requisite notice, which is fairly simple to do and provide, versus running the risk of having to provide liability for up to 60 days of pay in New York per employee for the violation period, in addition to the cost or value of any benefits that were not provided. There's also a civil penalty that's in play, as well as reasonable attorney's fees and costs. And I would say one thing that's important to understand about the New York WARN law versus the federal WARN law is that if you want to pursue a federal WARN law claim, you've got to go out and hire an attorney. There's no administrative enforcement action. Well, New York, in the legislation it provided, that New York State Department of Labor will enforce and does actively enforce the WARN law in the state of New York for violations. So you don't need to go get an attorney to pursue a WARN Act violation in New York. On the other hand, you also could go to court, and the significant WARN liability for employers is these are not single employee actions, obviously. These are actions, employment actions that involve a number of employees, thus implicating the possibility of class or collective actions where these cases are brought very often. So it can result in significant liability if you don't get the analysis right. So what we've been, thinking about all along since basically March of 2020 is we're going to be facing, lots of employers were facing these significant downturns in their employment levels because of decreased work available and frankly, very often, being shut down or required or suggested to shut down by the government. So both WARN laws have various exceptions, right, to the WARN notice requirement. So the 2 big ones that have been in play is the unforeseeable business circumstances exception. And that's an exception where you apply the exception to excuse notice if it's something sudden, dramatic, and unexpected that occurred to the employer. And, it's something that was really essentially a surprise. Very often it came up in the circumstance where there was a government shutdown of a facility or a government requirement that a product be no longer made available for sale. There's also the faltering company exception, again, that would provide an excuse for the notice requirement where you had a company that was in distress and was actively seeking capital to maintain its operations. There's also an exception for strikes and lockouts. And finally, the natural disaster exception as well. That would apply in situations such as the regulations talk about an earthquake, a fire, a hurricane. Those types of natural disasters could also apply to excuse the notice requirement under both New York and federal warrant. So most recently, we had the first case to come out deciding or applying the exceptions to the WARN law in the case of COVID. So in early January of 2021, the district court in Florida was faced with a motion to dismiss involving a case of Enterprise Rent-A-Car down in Florida. Obviously, significant downturn in travel in the United States had a number of corollary repercussions, including rental car businesses. So in Tampa and Orlando, Enterprise laid off 400 in Tampa and 108 in Orlando. Those were done, those layoffs, with little, if any, notice. They did try to assert the exception. So I think they would issue a notice, but say, we can't give you the full 60 days that's required under the federal WARN law. We can only give you, in the case of one circumstance, 8 days notice. In the case of the other, 0 days notice. But the employer asserted, we have an exception here. In fact, we have two exceptions that we're asserting. One is the natural disaster exception because of COVID, and the other is the unforeseeable business circumstances exception. Well, the court rejected at this stage the company's motion to dismiss on the basis of the exception. So the case is going to proceed now into the discovery phase. What's critical, I think, the takeaway with respect to this case, at least with respect to a Florida district court, is they've decided the natural disaster exception would not apply to the COVID-19 circumstance. That the natural disaster of COVID-19, even if it is a natural disaster, did not directly result in the layoff of the employees at the airport terminals in Florida. The more accurate type of description would be, for example, a flood that floods a factory and results in layoffs. Well, that's a direct result. If a flood in a particular area or a city resulted in, a depressed economy for that area, that might result in layoffs, but that is not a direct result of the natural disaster exception. The court did say that, the unforeseeable business circumstances exception may apply, but it's a factual issue for determination at a later stage. The critical thing is that under the unforeseeable business circumstances exception, an employer must give as much notice as is reasonably practicable. So it doesn't excuse notice completely, such as under the natural disaster exception. You still have to give some notice that must be made available. So for employers who may be looking at this issue in the future, I think the important thing to understand is, okay, we're going to be looking at layoffs over this next period of time. There are a number of other significant issues that you have to deal with in terms of aggregating layoffs over a period of time. But when you're looking at this and you're saying this is the result of COVID, I think you don't want to be sitting on your hands to say we've always got the COVID-19 excuse to assert at some point, because if you don't bring it forward immediately once you believe it may be applicable, you may still face liability, and certainly you're going to face the issue of potential litigation over the issue. And so you want to do the analysis up front, assert the exception, and give as much notice as you can under the circumstances to try to reduce any potential liability should it come your way with respect to WARN. So that's all I have on COVID and WARN. Thanks, Adam.
Colin, thank you so much. And a couple of things before we leave for the day. Thank you all for attending with us. I would point out that this webinar is only one of the ways that we communicate information to you and to our clients. We have a labor and employment blog that puts out articles on various topics. The topic Colin just talked about, the recent WARN case, we published a blog article about last week. I know Jeff and his group publish articles all the time, client information memos. So make sure that you're subscribed to receive all of those other sources of information from the firm, and keep track that way. I would also plug the survey at the end of this webinar. One of the questions that the survey asks is whether there are any additional topics you think we should be covering or you'd like to hear more about. Please let us know if there's anything that you really want to hear about, because we're happy to talk about it. So with those two things, thank you everyone and have a great week.